Hello, and welcome to We Can Work It Out, the podcast that explores the history, present, and future of workers' rights. I'm your host, Dr. Jonathan Lord. In each episode, we'll be delving into the stories, struggles, and successes that have shaped working lives. From friendly societies to people management, we welcome academics, activists, trade unionists, policymakers, and workers themselves to help us understand what fair work really means in a changing world. This episode's guest is Professor Douglas Brodie, one of the UK's leading authorities on labour and employment law, with a distinguished career as a scholar, educator, and legal historian. Douglas is an Associate Principal and Dean of Humanities and Social Sciences at the University of Strathclyde, where his teaching and research explores the development of labour law, contract law, and the historical evolution of the employment relationship. He has written extensively on the interaction between common law, statute, and collective organisation in shaping workers' rights and employer duties. Douglas has published widely, which have helped shape both academic and policy debates about the role of law in protecting workers and mediating industrial relations. Across his career, Douglas has contributed to public and professional understanding of how the legal regulation of work has evolved and what the history tells us about the future of employment in a world of precarious labour, automation, and globalisation. Douglas's book, A History of British Labour Law, 1867 to 1945, is a seminal work which offers a major re-examination of how labour law emerged as a distinct field within British legal thought, from the Master and Servant Acts through to the post-war foundations of the welfare state. The book argues that labour law evolved not merely through political reform, but through shifts in legal doctrine, judicial interpretation, and the rise of collective bargaining as a normative force. Professor Douglas Brodie, welcome to We Can Work It Out.
Thank you very much, and great to be here. And I'm absolutely delighted that you've chosen this particular area as one of your sessions in the talks.
Thanks, Douglas. It is a bit of a privilege to have you on the podcast. Can you tell us a little bit more about yourself and how you became to kind of work into academia and become a leading scholar around labour law?
Um, I've been incredibly fortunate, I would have to say. I mean, I date from a time when becoming an academic in the early 1980s, it was so much more amateur than it is nowadays. It was much easier to get into academic life, whereas now I see, if I'm on an interview panel, you see all these really talented people who have done PhDs and they're fighting against each other to get their first job and so on, get onto the initial rung on the ladder. It was much easier in my day. But I was incredibly lucky because I was taught at Edinburgh. I was introduced to labour law in the autumn of 1981 by Keith Ewing, who was at Edinburgh in his first teaching job before he went to Cambridge, and then at King's, where he still is. And that was absolutely fantastic. And I was brought up on a diet of the works of Otto Freud and the second edition of labour law, people like Wedderburn, Paul Davis, Mark Friedland, Bob Simpson. Under Keith's inspirational teaching, fantastic introduction to the subject, and it's inspired me and kept me motivated to this day. And then I was very lucky because Keith went to Cambridge in 83, and I applied for the job, and I had two publications, both about 1,200 words long, and bizarrely, I got the job, and and that wouldn't happen nowadays. So that's why I've been really lucky.
Mm-hmm. So the book we're going to talk about today then starts in 1867. Why did you choose this as your starting point, and what makes it such a defining moment in the legal regulation of work?
Sure. No, it's a good question, and part of the answer is a very open and frank answer. To some extent, it's arbitrary. I mean, I think you could have chosen a number of dates. I chose then because that was the year, I think, they set up the Royal Commission that led to the 1870 Act and Trade Union Act of 1870. And that's recognisably the start of the modern legal framework for trade unions. You can trace, the current provisions back to 1870. So 1867, against a backdrop of a lot of industrial unrest and allegedly violent unrest on picket lines in the UK. It's the Royal Commission that's established then, that leads to the 1870 Act, and that really, can be seen as the first steps in terms of, the modern framework, which still pertains to some extent to this day.
Yeah, it's when I read it, it was a fascinating part of history, really, and
No, absolutely, and the whole debate about voluntarism and how true that was, or abstentionism, how true that a depiction that is. I mean, that continues to this day. Um, but certainly, bringing trade unions into a sort of quasi corporate framework. I mean, that does date from 1870.
yeah. So before that, before 1867, you talk about the master and servant framework.
Yeah.
What were the main characteristics of that relationship or the framework, and why was reform so urgent? Because it's quite even now it's quite a strong terminology, isn't it? Master and servant.
Absolutely, and of course we now talk about it a lot in terms of trying to explain um, how the contract of employment is constructed, and people will say that certain, key implied terms, duty to obey orders, all that sort of stuff, that takes its flavour. People will say from that old master and servant regime, but at the time, that would have been the least of workers' worries because the legislation had a significant criminal element to it, and while there was potentially criminal sanctions against both employers and workers, the application in the hands of local magistrates and so on, unbelievably one-sided, and it was used often because of the criminal element. It was often used as a tool in strike breaking to diminish the right to strike. Diminish the power of the collective, and strikers might well be imprisoned under the regime. So at the time, I mean, this is all obviously sort of long forgotten, but at the time, very one-sided, very punitive. And if you're going to have anything approaching any equality of arms in industrial relations, it was something that had to go.
So how did the expansion and rise of trade unions during this period influence lawmakers' understanding of work as a public, not just private concern? Because there was that change in philosophy, wasn't there, during this period that you've looked at?
Yeah, and I think it probably predates that to some extent as well. I think probably the health and safety dimension, and the need to protect children in workplaces, given the values of the time, women were seen as a higher priority to protect and so on. So the health and safety dimension, I think, right throughout the 19th century is really important. Obviously, trade unions play their part um, in that, and securing numerous um, pieces of legislation across the 19th century. The other thing as well, going back to the 1870 Act, I mean, trade unions, part of the reform that trade unions are responsible for, um, is convincing the public and Parliament that they're a legitimate part of the setup, and then
Mm.
they do get quasi-corporate recognition in the 1870 Act. So it's partly explaining that they have a legitimate role to play in industrial relations.
Just on a side note, so trade unions, what are your kind of overall thoughts of the trade union movement? I suppose at the time and now, because there's lots of discussion now, isn't there, about sectorial bargain rights? What are your current opinions of trade unions in terms of its influence in the workplace?
Well, I mean, I think maybe one of the big worries is that this is a time when trade unions were becoming, more and more influential, and so on. And then there's massive debates within the unions themselves as to some of the older trade unions. Trade unions were very cautious, very incremental in terms of how they make progress. Other, union activists wanted to be much more radical, and so on and so forth. But I think one of the worries now is that the attacks on trade unions in the sort of neoliberal phase have been actually sadly very successful. And trade union membership in the private sector in the UK, as is well known, is now very low, and that's had a corresponding impact on collective bargaining. So, I mean, nowadays in the UK, to some extent, trade unionism, collective bargaining, they're kind of almost public sector features. They don't have that same um, impact in the private sector, and that would be seen, I think, as in terms of your activists in the second half of the 19th century. I mean, I think they would be dismayed, but also baffled that it had gone in that direction.
Yeah. Do you think the gig economy and precarious workers led to that, helped the decline of trade union
Well,
membership?
I think it was the decline predates. The rise of platform employment, gig employment, but that more general sense of the growth of casual employment, sort of, probably since the early 80s. I mean, that's had a major part to play as well.
Mm. One of the greatest part or strengths of your book is integrating judicial decisions into the broader history of social change. It's one of the
Mm.
big attractions for me when I used it for my research. How did the courts often see? How did the courts, which were often seen as a kind of a conservative institution, how did it respond to the growing influence of collective organisation and influence of trade unions? Like you said, they're becoming more and more powerful. What was the reaction of these institutions?
Yeah, I mean, it's a really, really interesting question to raise, and I think if you look at the after the 1870 Act comes in, and it's meant to be sort of legalization of trade unions, and there's related measures passed and so on. I mean, one of the issues is that it's a very volatile position. So you go through periods where there's nothing terribly much tends to happen in terms of um, judicial activism to sort of come up with an anti-trade union position, and then in the following decade, it's quite different. So it's the volatility is this kind of ongoing feature, and you see that in the next century as well, in the 20th century as well. But you do get clear signs that the settlement, if you like, in 1870, and there was a further act in 1871, some judges really do clearly, struggle with that, particularly with certain key activities of the time, like picketing, which was
Mm.
absolutely essential in the 19th century if you were going to make a strike effective. And there's major decisions. For example, there's one Lyon against Wilkins, English Court of Appeal, in the 19th century, which very, very anti trade union, and makes it virtually impossible to picket effectively if you're going to do it lawfully. So, complete conundrum for the trade unions. And in general, the law of tort through the so-called economic torts um, moves in different directions, but I mean, never quite, quiet at all. So, and then things culminate in terms of, as it were, anti-trade union decisions in the famous case of Taff Vale, which comes a little bit later.
Yeah. Well, on that case and the preceding one, Allen versus Flood, picking your legal brain, because they are two massive cases. Um, and I know Taff Vale judgment was repealed, wasn't it, eventually? But can you just kind of
Yeah.
go through what those two cases were about, what happened, what the decisions were, and what the impact of them were at the time?
Yeah. So, um, Allen against Flood, if it, they deal with quite different things. Allen against Flood deals with, um, I suppose the question is, what amounts to an abuse of economic power. Um, and what you had in Allen against Flood was a situation whereby workers were employed on very short-term deals, employment by the day type activity, which to modern eyes sounds horrific, but it was very much a feature for many workers in the 19th century. If people have seen the film On the Waterfront, it's that type of
Yeah.
scenario. So um, trying to go against a union or union organisers on the basis that they persuaded people to come out and strike by breaking their employment contracts and leaving their work, that doesn't really work because what you're really doing in practical terms is saying don't go back tomorrow. And don't sign up for another deal. That's what it amounts to. So what Allen against Flood deals with is that the employer says, well, they might not have broken a contract with me, but the union still interfered with my economic interests because it's persuaded people, not to work for me, whatever. And Allen against Flood, the big question for the House of Lords is whether um, intentionally damaging someone economically does that give rise to liability, or do you have to show that they've used some unlawful tactic, like persuading people to break their contracts or whatever? And Allen against Flood um, takes the view that simply interfering in someone's economic interests, that doesn't give rise to liability. So that's hugely important for trade unions at the time. But again, going back to my point about just how volatile things were, you've got another case, Quinn against Leatham, several years later, where they don't overrule Allen against Flood, but they do qualify it quite a bit. So that was one of the difficulties for trade unions and trade union leaders and so on. Life rarely remained the same. They didn't have that stability. Even if you get a decision like Allen against Flood, how long can you rely on that, and so on. And then if we come to Taff Vale, Taff Vale was one of the if you're looking to make a case that the judges at the time were anti-trade union, I mean, Taff Vale would be the one that you would really absolutely major on, because the 1870 Act didn't give trade unions corporate status as such. And the assumption had been that if an employer wanted to sue for damages, if they'd lost money because of a strike, the only people they could sue would be the trade union organisers. They couldn't sue the trade union itself because it didn't have corporate status. It wasn't a company, wasn't incorporated, and that had been the assumption for many years. But in Taff Vale, the employer tries to sue the trade union, and they win at first instance. It then goes to the English Court of Appeal, and people forget about the Court of Appeal judgment. But the Court of Appeal judgment, relatively short, and it says you can't sue the trade union because this is a question of interpretation of the legislation, and it's actually quite easy. You can't sue the union. That's what it says. So it then goes to the House of Lords, where they have no difficulty in finding that you can sue the trade union, but actually the arguments are much weaker. But the best um, um, critical analysis of the judgment of the House of Lords is actually the Court of Appeal at the time. If you go back and look at what the Court of Appeal says, it's really damning of what they say in the House of Lords. And that caused, a huge uproar at the time, and eventually leads to the Liberal government in several years later, reforming the position and restoring what was always meant to have been the case in the 1906 Act.
Do you think because of the politics of the judiciary that was emerging, because you can quite clearly see it being bounced around in different levels of the court system, do you think that was a catalyst for the Labour Party being introduced and trying to assist with the judiciary and the politics and the introduction of legislation? Do you think it was a catalyst for the Labour Party being set up and being introduced?
I think it was definitely would definitely been part of that. I think partly because the alternative to conservative governments at the time was Liberal, the Liberal Party, who were obviously far stronger then than they are today. But they were seen, I think, as much more of the establishment. So if you're going to get any significant action taken, then things like Taff Vale are great, means of recruitment for the Labour Party. Yeah.
Yeah. We obviously then had the First World War. How was this a catalyst as well for the development of labour law? I mean, it could have obviously distorted it as well, labour law, because I think there was a general ban on industrial action, wasn't there? I think, and then lots of
Yeah,
strikes
yeah.
took place in the docks and in Glasgow with the munitions factories. How did the First World War kind of im- accelerate
Yeah,
or distort
so,
labour law?
it's interesting. I think there's probably two general points I would make. One is there's, a number of measures, which are quite, tough, draconian, that are introduced. Um, there's restrictions on the, mobility of labour. There's wage control, brought in. There's compulsory arbitration and so on and so forth. And I think one of the things that's interesting, about all of this is that, in some ways, the difficulties, even in wartime, of making sure these sorts of measures were effective, made sure they were really very much an interlude. So, and that once war's over, there's not really any desire on it, any position across the political spectrum to retain these sorts of tougher restrictions. The other thing I think that's interesting, though, and there's quite a big contrast with the Second World War here, is that there are um, um, some, much more positive things in that happened during the war. There's Whitley councils are introduced, and collective bargaining's promoted to some extent, and so on and so forth. And that promises, um, well, augurs quite well for what reform might look like post the end of the war. But then there's a relatively short honeymoon period after the war, and in no time at all, by the very early 1920s, you're into huge economic problems, trade depression, all the rest of it. And that kind of kills off a lot of the, the kind of the positive, promising things that had kind of started to kick off during the First World War. I think there's also an interesting lesson from government, because they realize that if you start to try and control wages in one particular sector or whatever, it becomes very difficult to confine the extent of your intervention. If you deal with workers in one particular area, it's quite difficult not then to regulate workers in related trades and so on and so forth. So the history of things like wage regulation demonstrates that once you start to get involved, you're kind of caught in um, really in ongoing calls and needs to regulate further, and that's, if government reflects on that, that's not really a place governments at the time wanted to be in.
Yeah, well, you mentioned in your book there was lots of committees and white papers around permanent joint industrial councils, expanded collective bargaining, more regulated labour market
Yeah.
framework. What kind of happened? Do you think? How did it progress, and why didn't it come to fruition? Was it the Second World War, or was it other political, or social, or societal, or economical influences?
I think it's very changed attitudes during the Second World War, um, that look back, I think, at the disappointments in terms of things that have been sort of talked about in the First World War started, but they don't come to fruition. And I think trade unions, labour movement in general, there was a real determination during the Second World War that the same thing wasn't going to happen twice. And that workers, in a sense, weren't going to be deceived by promises of a much better industrial relations landscape post-war, to buy them into the war effort. And then, the Second World War, um, the from quite early in the war, you've got Ernest Bevin, for example, having a senior position in government, and so on and so forth. It's very different.
Yeah. There are people like Sydney and Beatrice Webb. I know they've written a lot about the history of trade unions. How influential do you think? commentators like that were in trying to separate labour law from general contract law? How influential were commentators like that at the time?
I think they were very, very influential, and along with with the trade union movement, labour politicians, and so on. Um, I think that they played a big part in demonstrating that you know poverty and so on, whether dealt with through labour law or whether dealt with by social security measures like the pensions regime came in for the first time in 1909. But they played a big part in demonstrating that poverty had to be addressed through a variety of measures, including labour law measures. I mean, the predecessor of the wages councils, the trade boards, started in the first decade of the 20th century. Um, there's government when it comes to procurement. There's fair wages clauses and so on. I think the fair wages resolution dates from 1891 or something from memory.
Mm.
There's legislation for 1912 Act dealing with hours and conditions in the mines and so on. So there's an awful lot happening. But what people like the Webbs are doing is that they are getting across to a wider public just how terrible that the conditions are for working people at that time. And there's also, you can see prior to the First World War, um, the sort of early embryonic stages of a greater desire to promote collective bargaining more effectively. Though I think at the time, um, the trade boards were primarily about ensuring in these particularly grim industries, ensuring some form of reasonable rate of wage. The rationalisation of them as a uh, means of promoting collective bargaining is to some extent retrospective, but yeah, I mean the Webbs are and others are hugely influential in this, and um, the Webbs. I mean, Beatrice Webb. There was a poor commission in Royal Commission in, well, forget the date, but round about 1907, say, and um, Beatrice Webb was a member of that, and indeed there was a minority, more radical report on that, which she was one of the authors.
When I did some research for this, I didn't realise they were part of the Fabian Society, the Webbs, weren't they?
Yeah,
Yeah,
yeah.
which I didn't realise that, 'cause I know they've had a lot of influence in lots of things, but, they were big proponents of it and helped found sections of it as well.
Yeah, and another name that pops up for the time, and it's probably forgotten, is Beveridge, because Beveridge lived for quite a long time, and of course he's best known for nowadays for his report in the middle of the Second World War, and the contribution that made to the founding of the modern social security system. But he's
Mm,
also very active at this time, and um, he's very much promoting in a report he was involved in, very much promoting labour exchanges, which had taken off in Germany. And Beveridge has this idea that if the state becomes more involved in the labour market, part of the problem is kind of matching workers to employers and all the rest of it, and that labour exchanges can play a part in that. So um, there's a number of very powerful intellectuals at the time, chucking ideas into the mix, and to some extent, the First World War came at the wrong time from the point of view of labour, because there was a good deal of momentum building up towards reform, and very sort of considered and well informed reform.
mm. What was Britain's approach compared to, say, continental Europe? Did it differ? Was it similar? Was it a kind of mismatch of what other countries were doing at the time?
Yeah, I mean, quite a bit of the continent is legal regulation plays a much bigger part. So that, for example, collective bargains between trade unions and employers would be legally enforceable. There'd be much more likely to be a right to be recognised by the employer for collective bargaining and so on. So, um, quite a lot of differences, and this, of course, led to the great Otto Freud's analysis, that Britain was voluntarist in terms of its approach to industrial relations, that the law had a very much a secondary role, and whatever views nowadays differ in how convincing analysis that was. But I think in the time period depicted, 1900 to 1960, whatever, it is a very strong case, and that you know, Freud, having fled to the UK as a German Jew in the early 1930s from obvious concern about persecution in a fascist regime, that comparative piece was hugely influential for Freud, because I think that comparative lens allows him to see just how different the UK was, and whereas an insider might not have portrayed it in that way.
Mm. His wife was influential, wasn't she? Because she did a lot of his research and was a legal scholar herself as well, Karen Freud, which again I didn't know until we've got a couple of academics recording a podcast about her, because she was very influential on his work as well, Karen Freud.
Yeah,
In
no,
terms,
I didn't realize that either. Um, the my colleague Rebecca Zahn, who's doing some fantastic work on various aspects of labour law history, she's got an article in Industrial Law Journal recently on Freud's wife, and indeed managed to speak to Freud's daughter, who is still alive. I think Canfroy and his wife adopted a daughter, sort of later in life, as it were, which explains why um, you know the daughter's still very much alive,
mm,
and was very interested. But yeah, no, it's that's been, I suppose, a less well known part of labour law history. But yeah, but
yeah.
Canfroy's wife is well worth a mention.
So in between the First and Second World War, then the interwar years, um, there was a Great Depression, which obviously had a massive impact on labour in the institutions. How did that Great Depression
Yeah.
and unemployment which came out of it, how did that shape the trajectory of labour law then? I know you've kind of intimated it, but what was the real impact on labour law?
Yeah, well, I mean, and the real impact, I suppose, was that under predominantly, conservative regimes in Parliament for the bulk of that 20-year period, very little was done to build on any positive elements that emerged in discussion during the First World War. So to some extent, progress is put on hold for that 20 years. There's also, I think, a kind of uh, early indication that government starts to realise you can control the labour movement and trade unions by economic policy, because you've got throughout this period hugely economically conservative people in the Treasury, and economic tools, keep um, the labour movement, pretty much suppressed. And I think that's an early indication of what was going to happen in the 80s with monetarism, which was because we tend to often discuss control of the labour movement and trade unions in terms of legal mechanisms, but economic policy and economic tools are a very powerful weapon the state has as well, and maybe less consciously than in the 80s. But you're seeing that use of economic policy as well. It's not to say that there weren't any positive measures. There were some, but it's not a good period in terms of the state doing anything positive for labour law. Um, I mean, there are some saving graces. I mean, after the general strike, there's a great deal of pressure to bring in restrictive trade union legislation, and that led to the 1927 Act. But the 1927 Act doesn't actually do very much. And the Prime Minister at the time was Stanley Baldwin, who was, I suppose, in modern language, more of a one nation sort of conservative. So, and not one to look to overly penalise the trade union movement for the general strike. But not a good period overall.
Mm. By 1945 then, because we saw during the Second World War, like you've intimated, it was slightly different, wasn't it? We had the wartime controls, but we had things like the National
Yep.
Arbitration Order, consultation um, through unions, through joint bodies. It was a lot more positive, like you said, and a lot of foundations were kind of set down during that period. What institutions now that changed during that period are most influential today, do you think, looking back?
Yeah, I mean, I mean, that's another really interesting question, and in some ways, it's perhaps quite depressing. I mean, we spoke earlier in our conversation about how collective bargaining's changed and become much more of a public sector phenomenon, as opposed to something that's comprehensive across the different sections of the workforce. But that you know collective bargaining is something which hasn't perhaps survived as strongly as you would have expected. Um,
Do you
mention
think
of
that will co
beverage as
do you
well.
think that will come back in collective bargaining a bit more now? There's a lot of, the Institute of Employment Rights talked about it a lot in response to employment rights, but do you think collective bargaining will see a resurgence or not?
I'm not convinced because I think of wider changes in the labour market. We've also talked about platform employment, precarious employment, and because
Mm,
that's such a significant part of um, the labour market now, and in areas like that, it's very difficult for the trade unions to recruit. So I'm not convinced it'll change radically, for the foreseeable.
mm,
Um, I mean, another thing which obviously beverage again was very much influential in was the um, commitment to full employment. Now, I think one thing has changed there is that while I think politicians are very much still aware of that, apart from odd exceptions like the Thatcherite years, full employment now is often perhaps not very good employment. I mean, a lot of people have, you know, very unsatisfactory, not particularly well paid jobs. So you might still have full employment, but do you have full and good employment? So
yeah.
there, that's a doubt. I mean, obviously the NHS was set up during this time, and again, that's in real difficulties nowadays. But one thing I think is really interesting, going back to beverage, um, is in terms of social security. I think this is something which could become of greater interest to labour lawyers because um, going if you pick up again on a precarious worker point, um, whether um, workers outside the sort of traditional employment type relationship, whether other workers, Section 230 workers or um, sort of people that are allegedly self-employed and quite small time and so on, um, whether that wider range of workers that we see in the labour market now, whether it's realistic to think they'll all get full labour law rights, I'm not so sure. But I think what is of interest in terms of where the modern sort of movement from beverage are the current interest in universal income schemes, because I think that people, more precarious workers that might not be employees, how do you protect them? I think labour law as such might continue to offer them limited protection, but they might in future look to things like universal income schemes, change in taxation, and so on and so forth. So it'll be kind of more like a portfolio approach in terms of how you bring rights together. So in answer to your question, I think social security as being a kind of uh, fundamental right of us all, if you like, I think that might see a modernisation and so on over the next 25 years.
You mentioned Lord Wedderburn before. I met him just before he passed
Yeah,
away, and he was an immense
yeah,
character in terms of, labour law. Very well regarded, very
yeah,
eloquent when he spoke, and he was mainly talking about the judges sitting alone on tribunals just before it came in. He was advocating the tripartite approach of lay members being on the tribunal panel. He was a big
yes,
advocate. You need that lay membership, but he also talked about the voluntary system, and he said he liked the mixture of government intervention with either the control through acts and legislation, the tribunal system. He was a big advocate of the tribunal system,
yeah,
employment tribunal system, but he also said the necessity of collective legislation or collective protection as well. You need both individual and collective approaches to protect workers because the
Mhm.
more protection you have, the better it is for the workers. What's your kind of current stance on that at the moment?
Well, my position would be that enforcement is one of the key issues um, of our time. So that um, you've got individual rights, you've got collective rights, and I would agree with what you say about your take and some of the Wedderburn position. But I think where we are at the moment is that it's often very difficult for workers to enforce rights. So I think some of the things that have been talked about in terms of the Employment Rights Bill and a Fair Work Agency type approach, to me that's the way forward. Um, very difficult to um, often for workers to enforce rights, and even when workers win, I mean, if we've been talking about platform work and so on, if you take the famous Uber case from 2021,
Mm,
um, that deals with Uber's position um, under that particular deal, which dated back to 2016. Now, Uber have no doubt issued new contracts since that decision, and it just goes on and on.
mm.
So relying on individuals to be able to get their act together, get people to back them, and so on and so on, really difficult. So I think for me, enforcement's one of the key things nowadays.
Yeah, we've just finished some research around the P&O sacking scandal
Yeah,
in 2022, and one of the seafarers, John Lansdowne, he's come on board with some research, and we spoke to some of the seafarers who were sacked on the day,
yeah,
and that P&O effectively circumnavigated, pardon the pun, the laws. They sacked everybody on that day, so the trade
yeah,
unions couldn't really protect them in the right way.
yes.
They paid them a settlement figure, but they had to sign non-disclosure agreements or the settlement agreement. So, even high-profile cases highlight the fact that enforcement is, a proper enforcement anyway, is still required even
Mm.
now.
No, absolutely, and the notion as well that a layperson can go to an employment tribunal um, and argued her case. I mean, it might have been feasible, at the point of the setup of the system, but nowadays with I mean, if you take something like constructive dismissal, I mean, how someone a lay person is meant to work out whether there's been a material breach of an implied term. I mean, I really don't know.
Yeah. Yeah, it's very, very complex now. I agree. It's you need legal representation. I know it's free to submit your ET1, but you certainly need legal representation in the more complex cases.
Yeah, absolutely. Yeah.
So your book ends in 1945. That's the period you've looked at. Um, how has looking from then to now? How has the neoliberal period since, I suppose, the 1980s and the Thatcherite government altered or perhaps reversed what happened during the period that you look at in your book?
Yeah, well, I think, I mean, quite depressing. It's difficult to put it in a different way. I mean, I think um, if you look at many of the reports about conditions of working life in Victorian times, it paints a very harrowing picture,
Mm,
and we've seen a real return in this neoliberal period to the return of precarious work in very significant numbers, and the difficulties people have in making a living in that way. I mean, platform work, the gig economy is a major example of that. But as I say, precarious work. I mean, Uber wasn't founded, I think, until 2009. I mean, precarious work um, really kicks off from the early 1980s. So
mm,
that return to precarious work, I think that's a very sad feature of working life now. I think again, where people are often employed in under really quite unfavourable terms and conditions.
mm.
So that's another sort of harking back to Victorian position. And surprisingly, I think, as I mentioned earlier, I mean, the decline of trade union influence and collective bargaining in the private sector. And I
Mm,
don't think you'd have predicted that back in, well, I mean, it's even in the 1970s when things were quite topsy-turvy and so on, you would never, I think, have predicted it would go the way it actually has gone.
mm. Well, with the Uber case, wasn't their central argument in the Uber case that they were just a platform for providing work and they weren't technically an employer? That's that was their kind of
That's right.
centralist
That's right.
argument, wasn't it? Yeah,
And they still argue that. They
yeah,
lost in the New Zealand Supreme Court 2 weeks ago,
yeah.
and, um, they're arguing the workers are independent contractors, self-employed, and they're still arguing that. They're still saying, "We're a facilitator.
Yeah.
You want a taxi home, you're a driver, you need a passenger, we'll bring you together with our marvelous technology." And they're still saying that. And
Mm,
part of the difficulty is, I mean, we talked about, I talked about the people that introduced me to labour law were, inspirational and so helpful. But, you know, people like there's a long context, and I would say to students, well, look at the Uber business model.
mm,
Um, this is inevitable because that's the context. They have to uh, defy regulation if they're going to make the money that they say they will for their stakeholders. So
mm,
and it's not just labour law they come up against, it's licensing schemes, other forms of regulation. But the whole Uber business model is based on defiance of regulation. So they lose to Supreme Courts all over the world. They've got an incredible record. And then, they change things a bit and move on.
Bringing things to a conclusion around your book, if you wrote a history, I'm not saying you have to do this, or you you might want to do now after revisiting it. If you wrote
Oh,
a history
thanks.
of British labour law, 1945 to the present day, 2025, what themes or turning points do you think you would dominate that story? Then you mentioned Uber. What other themes or turning points do
Yeah.
you think would dominate that story?
Well, first of all, I should say that there's a tremendous book by Paul Davis and Mark Friedland that I think deals with 1945 to 1990 roughly, and an absolutely phenomenal scholarship, which is what you'd expect from the two of them.
Mm,
I think there's different phases. I mean, post 1945, there's a kind of initial period of consensus, expansion, and so on. Um, you pro collective bargaining across the political spectrum. You get the Donovan Commission.
mm,
Um, so on and so forth. Bit topsy turvy in the 70s, but still going pretty well. I mean, I think a couple of things, big things I would bring out is that um, the decline in trade union power and decline of collective bargaining, Parliament's filled the space to some extent with much more of a raft of individual rights. But that then brings us back to our conversation about enforcement. So individualism is a much greater feature.
mm,
I think one thing's apparent as well was that you see from um, what we've touched upon as well is the use of economic policy to control the labour movement. Monetarism did that to an absolutely brutal extent. I mean, people really don't talk about monetarism now, but in terms of the attack, which it was by the Thatcher government in their time in office, while they're perhaps remembered now for the balloting requirements before industrial action and all that sort of stuff, at the time, the use of economic policy and the rigid adherence to the gurus like Milton Friedman and all the rest of it, that was massive at the time in damaging the trade union movement.
what can policymakers and lawyers today learn from the period that you've looked at in your book then, about the reforms, about the relationship between law, the justice and work? What can they learn from it?
Well, I think one thing that could be learned is that they do reform properly. I mean, the last Royal Commission we've had in our area, I mean, that's Donovan back in the mid-60s. Now, I know Royal Commissions have gone out of fashion in general, but you've got a Royal Commission then, and Victorians were very keen on government reports, inquiries, royal commissions, and you get, as a result, reports with underpinned by really strong evidence base. I mean, the Victorians, you know, you go to the shelves of the library, and then there's the principal report, and then there's appendices, 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 massive information. So you have that proper analysis, the evidence base. You've got a range of experts. I mean, we mentioned Beatrix Webb, for example, on the Poor Commission, 1907, and so on and so forth. So doing things properly, much more considered, I think would be a lesson you could learn. If you look, for example, at the Taylor Review from sort of 10 years ago, whenever it was, I mean,
Mm,
it's more like the sort of glossy you would read in the dentist.
mm.
In terms of um, limited investigation, you know, um, you know, relatively quick and brief write up and so on. The other thing I think as well is what we've just been talking about. The Victorians increasingly realised the need for enforcement. So inspectorates, use of the fair wage resolution, procurement, and so on. Um, these were lessons which the Victorians had discovered, and we've, particularly in the neoliberal phase, we've often forgotten about that when we've
Mm.
diminished the effectiveness of, say, the health and safety inspectorate and so on.
You're right. I've got an original copy of the Donovan Commission report. Someone gave me it when I first started in academia, and when I look at it, it's a manual. It's unbelievable. I know it looks at industrial relations, so it's a big scope they looked at, but it's unbelievably well researched and um, a good indication of what was happening at the time and how to support or reform things. And you're right with the modern reports, the more they're called white papers, aren't they? I suppose, but
Mhm.
they don't seem to have the depth of research or introspection about what's going on and what the reforms will be. They're just looking for the headlines, I think, now, and they're not really looking at
No, absolutely, and I think they're often looking to confirm direction of travel that government's
yeah,
already announced and
yeah,
so on. But I mean, if you look at the appendices and everything to Donovan as well, I mean, there's work in the shop steward movement and so on and so forth that wouldn't have been widely known prior to that. And
mm,
we talked about Second World War, and one of the lessons from that was the limitations on compulsion and criminal penalties. And there's a famous strike in the mines in Kent in 1942, and that's all aired in Donovan. Where they explain that stuff. If it didn't really work in wartime, it's not going to work in peacetime. So
mm,
there's that historical perspective as well in terms of what can we learn from the past, rather than the current position, how we go about things now, which you describe.
mm. So you're a very busy person. I know that. What are you working on at the moment or next?
Well, I mean, I've just produced a piece in the Industrial Law Journal on franchise, which is
Yep.
really it's actually really interesting that it's really under um, considered in either by academics, or there's very little litigation. But I mean, franchisees are often just as vulnerable as employees. So
Mm,
pleased to get that out. And um, uh, just started a book on termination of working relationships, which won't look at the rules comprehensively, but I'm more interested in kind of underlying policies and principles and so on. So working on that, and I've also working on a synopsis for a second book. Really interested in the way that common law systems have changed in terms of the contract of employment, but while the values have been the catalyst for change are fairly common, there's very interesting differences between the systems. So I'm trying to get at what are those differences to try and explain why, while everyone at common law has become a bit more progressive, they've not done it in quite the same way. Direction of travel can be a bit different. So a lot on the go at the moment. Yeah.
yeah. I was there for your launch of the Employment Law for a Brave New World book, and that's a really good reference point for
Mhm, mhm.
students, or people who are interested in that area as well, because you do look at really good scope. I think you look at employer voice, employee worker voice, and employee
Yeah.
voice, employee engagement as well. and the challenges of on-demand work as well. That's a really good publication that you've worked on as well.
And I actually agree. I mean, I didn't write that myself. But with Jalen Riley from Sydney, who's
Mm,
tremendous, and Gordon Anderson, who really excellent labour lawyer from New Zealand, and um, we went about it in quite an interesting way. Actually, we didn't because it's comparative. The easy thing would have been that I'd have written all the UK bits, and they'd have written the bits from their countries. But we did it differently. We divided the chapters up, and we all wrote the first draft um, comprehensively. So we included. I would write about Australia and New Zealand in my chapters, and so on. So I think that's helped make the book more integrated than otherwise it might have been. Obviously, wiser heads came in and told me I got Australian law wrong or whatever, but I think the methodology actually worked quite well.
yeah, that's the thick skin of academia, isn't it? You've got to be prepared to for all the opinions and advice that you get, but that shapes the work you do, doesn't it? I suppose.
Yeah, and I think I would. It's perhaps my age talking, but I think at times now we're over supportive,
Mm.
and I think, well, I think historical are probably under supported, but over supportive now, and you have to, in a kind way, you have to be able to be critical of other people's work because the only way it improves, and you have to be receptive to that too. I think we've become overprotective, over precious at times, and that doesn't help anyone.
No, no, I agree, and the resilience is a big skill set I think you need for academia now because the quality of your work has to go through that peer review process,
Yeah.
and you have to be able to sustain it and think about it, digest it, and then make amendments or work on things that people suggested, but have that resilience to be able to actually face what you're going to face when it is peer reviewed.
No, absolutely. Yeah, yeah.
So we ask each guest to choose one person or a group of people who they believe has influenced the world of work, positively or negatively. We've had some interesting proposals. Who would you choose to be that person or that group of people?
I would choose Otto Freud actually, and but my reason for this is that his analysis of the attributes of the employment contract and his depth of understanding of it, I think it's become over time incredibly influential on the courts and the judges in a way that when I was a student. Mentioned, read Labour and Law for the first time in the autumn of '81, and it was very much that the academy was, you know, in one place, and the courts and judges were somewhere entirely different. And then the Canadian courts were the first really to bring it in from the cold in the late 1980s, and they said, no, Canfroid's got it absolutely right. There's the relationship's inherently unequal, and we need to take that on board in how we develop the contract, how we interpret it, how we imply terms, and so on. And that's now accepted across the board
Mm,
in numerous common law jurisdictions. And you see the influence of that, for example, in the UK, the great mutual trust and confidence case of Malik, where the House of Lords as was endorses mutual trust and confidence for the first time. You know, that's clearly demonstrates that the judges have come on board, accepted Canfroid, and that influence of an academic like that. I mean, it's relatively unusual because we're talking about an influence that goes to the very full understanding of the basis of the employment contract. We're
mm.
not talking about an academic article that might influence the outcome over one very specific issue. It alters your thinking right across the board about the employment contract. So very unusual, massive influence, and um, nice for me because I've seen that change during my time because it seemed almost, radical reading Freud back in '81. And now, well, the judges think he's right. So you have to obviously have to move on and find someone, from a, um, you know, more radical perspective, perhaps.
Yeah, I think you're right. His writings have stood the test of time, I think,
Yeah.
and become mainstream now in terms of what the judiciary and labour law looks at. But you're right. It makes me laugh sometimes when you talk about the the power imbalance. Sometimes it's too towards the employee. How on earth can it be ever ever
Yeah,
be in favour of the employee when the employer is the word employer is we're employing you. So they must have that control. It's inevitable they have that control.
yeah, yeah.
Okay, well, it's fantastic to have you on the podcast, Douglas. You're an immense commentator on labour law, which is my kind of sphere. We're going to put a link into where people can purchase or get hold of a history of British labour law, 1867 to 1945, and your other works as well. Um, but thank you very much,
No,
Professor Douglas Brodie, for joining We Can Work It Out. Thank you very much.
no, it's been really interesting talking to you, Jonathan. Really good chat. So, thank you as well.